The future of fair voting rights hangs in the balance as the Supreme Court prepares to make a decision that could fundamentally alter the landscape of American democracy. In a move that has sparked intense debate, the court is considering whether to dismantle a crucial provision of the Voting Rights Act, a law that has been a cornerstone of racial equality in voting since 1965. But here's where it gets controversial. The case, stemming from Louisiana's congressional redistricting, challenges whether states can, or should, consider race when drawing district lines to comply with Section 2 of the Act, which aims to protect minority voters from discrimination. At the heart of this dispute is Louisiana's congressional map, which was redrawn last year after a lawsuit demanded the creation of 2 majority black districts in a state where 1/3 of the population is black. The original map had only one such district, raising questions about representation and fairness. The Supreme Court initially heard the case earlier this year on narrower legal grounds, but in an unusual step, expanded its scope in June to address a broader constitutional question. Does drawing maps to ensure majority black districts violate the 14th and 15th Amendments, which were enacted post-Civil War to guarantee equal rights, including voting rights, for all citizens? And this is the part most people miss. The court's decision could have far-reaching implications. Conservatives argue that the Constitution's colorblind principle prohibits any consideration of race, a stance the court has previously supported, notably in its 2023 ruling ending race-based college admissions. Louisiana, once defending its new map, has now switched sides, joining a group of non-African American voters who claim the map is unconstitutional. The Trump administration backs this position, while civil rights groups fiercely defend the map as necessary to protect minority voting rights. The Voting Rights Act has long been a target for conservative challenges, with the Supreme Court weakening it in 2013 and 2021. However, in a surprising 2021 ruling, the court upheld the use of race in redistricting to comply with the act in an Alabama case. That decision was a narrow 5-4, with Chief Justice John Roberts and Justice Brett Kavanaugh joining the liberal justices, though Kavanaugh expressed doubts about the long-term viability of Section 2. A ruling in Louisiana's favor could significantly reduce the number of minority-majority districts, potentially decreasing minority representation in Congress and state legislatures. This could particularly impact black voters, who overwhelmingly vote Democratic, potentially shifting the political balance in favor of Republicans. A quick decision would allow states like Louisiana to redraw districts before the 2026 midterm elections, adding urgency to the court's deliberations. But here's the bigger question. Is a colorblind approach to voting rights truly the path to equality, or does it risk perpetuating historical disenfranchisement? This case forces us to confront the tension between racial considerations and constitutional principles. What do you think? Does the court's potential ruling strike the right balance, or does it undermine the very protections the Voting Rights Act was designed to ensure? Let's hear your thoughts in the comments.